Welcome to the webinar entitled Crypto Regulation Demystified. Today, we'll be looking at navigating the risks of non-compliance. My name is Saeed Rahman. I'm a partner here at Rahman Ravelli, and I'm going to spend around 5 minutes or so introducing this topic to you all. As the firm is currently engaged in prominent crypto asset litigation and advisory matters in the UK, I personally hold a strong interest in this subject matter, and I'm delighted to participate in today's panel session. Now, we acknowledge that our audience today is diverse, spanning across more than 30 regions worldwide. While our main focus will be on the cryptocurrency regulation frameworks in the UK, USA, UAE, and a little bit of the EU, we understand that these specific regions hold significant importance in the global landscape. Hence, we hope this discussion will be informative and provide insights that can be relevant and useful for all of our attendees, regardless of their location. Now, we've seen a lot of action from the crypto regulation side. In fact, we've seen a lot of action just in the last 7 days, and it's almost very difficult to keep up. For example, earlier this year in February, we saw the UK Treasury publish its consultation paper for regulation. Just 2 days ago, on the 26th of March, we saw a new draft of the Financial Service Markets Act, which deals with crypto-related financial promotion. Now, considering the UK is apparently looking to become the global hub, the details of these regulations are likely to be a big deal for those in the digital assets industry. Furthermore, we saw a couple of days ago, the CFTC charged Binance for operating illegally and serving US clients. A mere 2 months ago, we saw Coinbase, a publicly traded company and a major global exchange, was penalized $100 million by the New York Department of Financial Services for its inadequate anti-money laundering and know your customer protocols that had persisted over a long period of time. Now, bearing this in consideration, the panelists of the event will scrutinize and deliberate on various regulatory concerns related to digital assets. We will be thinking about the growing importance of compliance and if and how regulators will be able to balance the competing interest of technological innovation with the necessary protection that customers require. I'm going to spend the next minute or two introducing our fantastic panel. But before I do, I just want to address a few housekeeping points. Firstly, this webinar will run for 60 minutes with an additional 10 to 15 minutes at the end for Q&A. Secondly, all of the listeners will be on mute, but if you do have any questions, please submit them through the Q&A feature below. Our aim will be to go through as many questions as we can after the 60-minute session. Finally, this webinar is being recorded and will aim to circulate a recording of this session. And I think it's usually disseminated in around 48 hours or so. So let's get started. First, we have Howard Fisher. Howard is a partner at Moses Singer in New York City. He specializes in financial services litigation, white-collar crime defense, and in representing parties in connection with governmental enforcement or regulator action. He's also a member of the Interdepartmental Digital Assets Practice. He was formerly a senior trial counsel at the US Securities and Exchange Commission, where he spearheaded the prosecution of multiple high-level cases involving the fallout from the financial crisis. Howard is a member of the New York State Bar Association's task force on emerging digital finance and currency. Next, we have Bushra Ahmed. Bushra is an award-winning litigation specialist, arbitrator, barrister of more than 20 years standing, and a partner at KBH in Dubai. Bushra is recognized by numerous legal directories as a ranked lawyer in dispute resolution, specializing in high-value international commercial disputes across a full range of areas, including regulatory, enforcement, and asset recovery. She's been involved in some of the groundbreaking cases in the UAE, the most notable being her success last year in the first cryptocurrency case in the Technology and Construction Division of the DIFC court, acting for the first defendant. Her reputation as a skilled advocate saw her recently win Litigator of the Year at the LexisNexis 2023 Women in Law Awards. All right, so I'm sure you'd all love to hear from our esteemed panelists, so let's get to it. Now, I'm sure everybody will agree the recent months have been very busy for regulation and enforcement. And I want to ask our panelists to go into detail about the implications of not complying from a global perspective, but also how it affects in the respective regions that you're in. So starting with you, Howard, can you give us the background that led to the penalties being imposed on Coinbase and the KYC deficiencies that were identified, please?
Sure. And let me just note that while the UK may tout itself as a center of the digital asset industry, the US and in particular New York State and the federal regulatory agencies that are headquartered in New York sees itself, and perhaps rightfully, and maybe I'm a little biased as a former regulator based in New York, but the US regulators see themselves as the regulatory center of the world. And as we've seen in, for example, the Binance case, the Coinbase case, and many others, US regulators see themselves as having global jurisdiction. As long as there is any connection to New York or to the US, and that could be something as simple as having a correspondent bank account here, US regulators see themselves as empowered to enforce US and local laws on global operators, even for conduct and even for persons who are not based in the US. So I think that's important to set out that context because it helps explain why US regulators are so aggressive in this space and are continuing to be so aggressive. So I want to just put this in a little bit of context. New York State was one of the first states to enact a regulatory regime for digital assets. And Coinbase was one of the, and I think that was as far back in 2015. And Coinbase was one of the first companies that agreed to be regulated and situated in New York and thus subject to the New York Code. So, just for those who aren't familiar with Coinbase, although it's been in the news so much that even if you weren't familiar with them a few weeks ago or a few months ago, you're probably much more so today. Coinbase is a global digital asset trading platform and exchange with millions of global customers, including many customers in the US. It obtained a license from the New York Department of Financial Services called the DFS in about 2017, and DFS is a state level agency that regulates all sorts of financial services, from insurance to brokerage firms to now digital asset platforms. So over the years, DFS conducted various examinations of Coinbase, and it found that they were severely lacking in a lot of KYC and AML, or know your customer, anti-money laundering adherence to those regulations. So for example, when they looked up customers, they would just have sometimes a photo on file. They would rely on self-reported information. They would rely on self-reports from social media platforms. They didn't actually conduct significant investigations into a lot of their customers. And this was seen as a significant compliance failure that violated the various New York banking laws and financial services rules about money transmitters, transaction monitoring, and cybersecurity companies. So what DFS was concerned about was that the failures of Coinbase exposed them to, or exposed their customers, or allow the platform to be used as a conduit for serious financial misconduct, criminal misconduct, and among the things that they identified were potential money laundering, child sexual abuse, narcotics trafficking, a whole range of things. And ultimately, the problem with Coinbase was that they treated their compliance and their customer onboarding program as simply a check your box exercise. They had certain things they had to do, certain things they had to check off in their internal monitoring system, and just having a system that checks a couple of ticks off a box is not sufficient. So this was a very substantial fine that was levied on them. I mean, it's $100 million, which even for a multi-billion-dollar industry, a multi-billion-dollar company, is very significant. And it's important, I think, to explain a little bit of what that $100 million consisted of. 50 million of that was a straight out penalty. The other 50 million of it was a commitment by Coinbase to invest in its compliance function over the next few years and to remediate what DFS saw as serious compliance failures. And this was something that Coinbase has been working on for several years. And in fact, this would have been a far more significant penalty if Coinbase hadn't been undertaking significant remediation efforts over the prior couple of years. And one of the things that the Department of Financial Services consent order set out was the various efforts that Coinbase had taken. And I think just sort of stepping back from Coinbase to a more 10,000 foot view, what we're seeing here is a failure to scale up as companies scale up. Coinbase was established, many years ago as a much smaller company, and as investments and activity in the digital asset space grew and became much more accepted, Coinbase failed to step up its compliance program, in lockstep with the way that the size of the company was stepped up. So this was a very serious case. And what it shows is that just because you are an actor in a newer space, the old rules still apply. There is an ethos in the digital asset space, as there is in a lot of tech, of moving fast and breaking stuff. One of the things you can't break, however, are the laws and the rules that govern how financial services industries traditionally operate. So Coinbase is a very good example of how traditional rules, know your customer, anti-money laundering, Bank Secrecy Act, Bank Reporting Act rules, are being applied to new actors in the financial services space. And I think the ultimate takeaway from this case, and if we have more time later, I'll talk about some of the other more recent cases like BitPay. Well, the lessons from this is, if you are going to be a serious grown-up company, you need to figure out what the rules are that are governing how you operate in your space. You need to comply with them, and compliance needs to be a serious function of the company. You need dedicated compliance personnel and constant working on your compliance function to make sure that as your company scales up, your compliance function scales up as well.
Thanks, Howard. I guess this case does serve as a sort of stark warning not to treat KYC as a simple checkbox exercise, as you've explained. And I guess it also establishes the importance of enhanced due diligence when you deal with high-risk customers, right? Okay, so
just one final comment. One of the main takeaways is you can't just rely on what people tell you about themselves. You need to conduct some kind of independent investigation into what people are reporting to make sure that that's accurate and true.
Agreed. And I'm sure we'll be discussing a bit more of that as the webinar goes on. All right, so I'm just going to turn to Bushra now. We've seen how the Dubai's Virtual Asset Regulation Authority, or VARA, has persisted in its role to safely integrate digital assets within the local economy. VARA also recently published its 2023 Virtual Assets and Related Activities Regulations, and no doubt compliance for exchanges and providers will now have to be a key consideration. Can you tell us about the implications for non-compliance in the region you are in?
Yes, of course. And can I just first start by saying thank you so much. It's a pleasure to share the panel with you. It's also wonderful to see how both you and Howard seem to think that both US and the UK regulators are leading the charge in relation to developing regulation. Whereas sat in Dubai here in the UAE, I would say that UAE has been a leader in developing the regulatory regime, which promotes investor protection, but it also promotes growth as well. So that's where the UAE is the leader. But coming on to sort of your question and addressing your point, VARA's persistence in developing its regulatory perimeter has been necessary, given the growth of the UAE crypto market. Just to give you a few statistics, Sid, the UAE share in the global crypto market has increased 500%, and that's between July 2020 and June 2021. And it's now estimated to be over US $25 billion in transaction value. The Middle East is one of the fastest growing cryptocurrency markets in the world, making up to 7% of global trading volumes, and that was according to Chain Analysis, which was then quoted by CNBC on the 26th of April 2022. And it's estimated that there'll be well over 1,000 crypto businesses in the UAE by the end of 2023. And so with that in mind, the persistence by VARA, we would say, is well placed. But before I dive into answering the question completely, I think it's relevant to the audience, for the audience perception, to understand and look at the UAE crypto regulatory landscape. Because the legal situation in the UAE is rather complex, because there's an interplay of a number of jurisdictions within UAE. And to understand it, one has to understand how cryptocurrency is regulated in the UAE. Because you've mentioned VARA, but VARA is the regulator onshore in Dubai, and there are other free zones that operate within Dubai. And within that, obviously, the UAE is made up of 7 emirates. So it's not just Dubai, there's Abu Dhabi, Dubai, Sharjah, Ajman, Al Quwain, Fujairah, and Ras Al Khaimah. And all of these have an interplay in terms of how cryptocurrency is regulated in the UAE. And the starting point is the Central Bank of the UAE and Securities Commodities Authority that generally governs the monetary and capital markets. Then in the DIFC, which is the Dubai International Financial Centre, which is the free zone operating within Dubai, that's regulated by the Dubai Financial Services Authority, the DFSA. And at the same time, you also have the Financial Services Regulatory Authority, the regulator in the Abu Dhabi global market, the ADGM free zone, operating out of Abu Dhabi. And so one thing to say about Dubai is that it's anything but tradition. And we would say that in terms of VARA and its setting up, that was set up on the 28th of February 2022 under a law that was promulgated and issued for the purposes of regulating virtual assets, and that's a regulating virtual assets law. And VARA is an independent regulator. And so where in other jurisdictions, for instance, the UK and the US, you have seen the regulators expand their existing regime, VARA has been set up as a bespoke regulatory authority. It's an independent regulator, and it's tasked with specifically the governance and licensing of cryptocurrencies, non-fungible tokens, and other virtual assets in Dubai. And that leads me on to quite an interesting debate, because in the DIFC, the DFSA, and in ADGM, the Financial Services Regulatory Authority, they have, rather than setting up a bespoke regime, have used their existing regime and expanded it. And so one of the debates is whether or not the approach adopted by, let's say, onshore Dubai, in that they have their own independent regulator, whether or not that's a better approach, or whether or not the alternative approach is using your existing framework and expanding it is a better approach. But let's see. Now, in terms of sort of the regulatory perimeter, and again, coming back to VARA, VARA has issued regulations, and those were issued on the 7th of February this year. And basically, it's allowed for specific rules, including exchanges, that cover all virtual asset providers, and that is that they must be licensed by VARA to operate in Dubai. And to secure a license, the virtual asset providers must meet a number of requirements. These are including but not limited to demonstrating that the virtual asset providers have adequate financial resources to operate its business, implementing solid customer due diligence procedures, establishing effective policies and procedures in order to manage potential risks associated with virtual assets, establishing adequate systems in relation to anti-money laundering and terrorist financing, and establishing effective governance controls. And so just addressing full on your question, now that we've sort of have set up the regulatory background, the virtual asset providers that are operating in and out of Dubai are now subject to increased regulatory requirements as a result of the regulations. BARA will monitor all virtual asset providers in order to ensure that they comply with the regulations. BARA has also issued associated rule books, and therefore those rule books will need to be complied with. And also the regulations provide that the issuance of anonymity-enhanced cryptocurrencies and all virtual asset activities relating to them are prohibited in Dubai, and therefore that increases customer protection. Non-compliance with BARA in the first instance will lead to BARA issuing a cease and desist order. There is then the penalties regulation, which is meant to be read in conjunction with the marketing regulation, and that sets out further penalties. And so in the event of non-compliance, with regards to the fines, these start at 50,000 dirhams, and for repeat offenders, they can go up to anything up to 500,000. In addition to a fine, there are other regulatory sanctions which have teeth, and that is the prohibition to market for a period of 6 months, revocation of any licenses that have been issued by BARA, and also BARA requires the entity that's in breach to issue a public statement confirming that it has breached the marketing regulation, and therefore there's full disclosure within the public domain about breaches by the entity. And I mean, my takeaway is that there are significant developments which are a massive effort to enhance the credibility and reputation of the crypto industry in Dubai. The objective is to increase public confidence in the market by setting adequate regulatory standards and requirements. And Dubai's aim is to establish an advanced legal framework in order to protect its investors and offer standards of governance. And you asked me about BARA, and I've also sort of touched upon the DIFC and the ADGM. Very quickly, the DFSA, in the DIFC, implemented the crypto token regime. And as I've already said, that simply expands the scope of many existing financial services activities, including provision of products and services, advising, dealing and arranging, trading and custody. And it simply has taken its existing laws and amended those. However, there is a limitation in DIFC, and that is that any licenses or any services or activities conducted in the DIFC in relation to crypto tokens has to be those that are recognised, and recognised is a defined term. And initially a list was promulgated, and it recognised Bitcoin, Ethereum, Litecoin as recognised crypto tokens. Obviously, we will see that this list being expanded once applications for licenses are made. And again, there are similarities between the regime in the DIFC and the ADGM, but there are also differences as well relating to how fiat tokens are treated and how derivatives and funds are treated. And so in that context, that's just a quick running summary of the regulatory regime and the perimeter within the UAE. I think just one takeaway is that if virtual asset service providers are thinking of doing business in the UAE, then given that there is a choice of regimes, they would have to consider which jurisdiction best suits them, depending on their activities, depending on their business model. But I think one thing is that it's quite refreshing that a virtual asset service provider or an investor has this kind of range of regimes to consider and choose from.
Well, thank you very much for that, and kudos to you for summarizing such a dense sort of framework in a short period of time. Well, look, I'm going to spend a few minutes to talk about the UK perspective, and there is a challenge of regulating crypto for anti-money laundering. For example, when you look back at the Payment Service Regulations 2017, money would generally be transmitted through intermediaries or payment service providers, right? And those intermediaries would be authorized by the FCA and would be regulated as well. So it would actually make transactions easier to monitor. And I believe the US have a somewhat similar concept through the sort of Bank Secrecy Act 2. In the world of blockchain and DeFi, however, it enables the legal exchange of money with no intermediary whatsoever. The transactions require no administrative oversight and largely tend to be somewhat anonymous. So with that in mind, regulators, I think, need to think about how to implement new technologies such as DeFi and DLT, and how that can be implemented into traditional financial infrastructures. In the UK, the Treasury are looking at a broad set of activities that fall into both the existing framework that we have, but also adding some bespoke regulations to it. And some of those activities include custody, trading venues, market abuse, and customer protection. And from what I can see, there are actually two sort of major changes to look at when you're looking at the issue of implications for non-compliance. First is the expansion of Section 21 of the Financial Service Markets Act. And second is market manipulation. And I'll quickly go through both of those. Just a couple of days ago, as I mentioned earlier, we saw the new draft of the legislation which deals with financial promotions. Now, it's a bit of a mouthful, but bear with me. It's the Financial Services Markets Act 2000 Financial Promotion Amendment Order 2023. No pressure there. If it helps, it will be referred to as the draft FPO going forward. Anyways, from what I see, the latest updates show there is a legislative desire to make a real mark in the crypto sector. It shows how the FCA will provide for regulation of certain crypto asset promotions and restrictions too. And to me, these are promising signs from what I can gauge. And I think this is what the crypto industry actually want. I mean, clarity is what we need on something like this. And personally, I'm supportive of those changes. Second is market abuse. Now, the FCA pledges to improve its ability to detect market abuse through, a significant upgrade in their market surveillance systems, et cetera, et cetera. Now, for me, it will be interesting to know actually how many of these investigations will actually be opened. The FCA will need firepower. There's no doubt about that. And they'll need resources to deal with something like this. And the consultation paper and the draft FPO provides a method where investors are now better protected. And it's a little bit of what Bushra touched on as well in terms of protection. And I believe, to be honest, I think this is extremely effective bait to use. And I think it will attract those reputable companies in the crypto industry and consumers. Now, it can be argued that the UK is still falling behind the EU regulations, or better known as MiCA. However, I believe being first isn't always an advantage. There's an opportunity here to actually refine and perfect MiCA. And UK regulators can look at MiCA and look at what's going on in other regions such as US, Dubai, etc., and find a way to actually perfect the regulation. And on that note, I think it would also be interesting to know what others think, including the sort of audience. Okay, so moving on. The Coinbase penalty is a good example of how exchanges can be slow or lax when trying to onboard customers. And in the consent order that Howard referenced, there were findings that Coinbase at the time of onboarding were not screening customers appropriately. So Howard, can you explain the importance of customer due diligence in accordance with regulations and guidance, please?
Yeah, and we refer to the Coinbase case as if this is the only guideline that we have, and it's not. I mean, this is not just a recent issue. Right. I mean, it's kind of remarkable to think that when we were originally talking about this panel, We were talking about Coinbase because it was one of the more recent examples in the space, in the digital asset space, in the regulatory space, looking at these know your customer and onboarding review issues. Since then, we've seen the Binance lawsuit by the CFTC the other day, which, among other things, touches upon their customer onboarding process. We saw a week or two ago the BitPay settlement between the New York Department of Financial Services and BitPay. And BitPay, for those who are unaware of them, is a payment service provider that allows merchants to accept Bitcoin payments from customers in exchange for the local equivalent in fiat currency. And that case as well was the result of examinations by DFS that found significant problems with BitPay's customer compliance function. And just like in Coinbase, the DFS found in that case that they devoted insufficient resources to the customer onboarding process and the know your customer process as well. So in the US, at least, I think it's helpful to look at this from the perspective of what the regulators are concerned about. And there are two major concerns that US regulators have. The first is that bad actors of all kinds will use the mechanisms of an exchange or another digital asset platform to promote misconduct. So this includes getting payment for crime, laundering the proceeds of crimes or fraudulent schemes, or using exchanges to hide the proceeds of fraud, which was one of the big issues in the CFTC's case against Binance. The second concern is customer protection, making sure that exchange clients are fully apprised of the risks of the transactions in which they're engaging in, that the source of their funds is fully vetted, as well as what the risks are to them of engaging in digital asset transactions. So this highlights the importance of having a robust and fully built out internal compliance system. Any entity that wants to operate in the US, especially in light of heightened US regulatory requirements, needs to prioritize due diligence in accordance with the appropriate regulations and best practices. And this means four things. It means a whole bunch of things, but I think I want to highlight four things. First, and this is incredibly important, is it needs the due diligence process in customer onboarding needs to ensure that the source of customer funds is fully vetted. Second, and you alluded to this in your reference to the Bank Secrecy Act, the compliance system needs to ensure that suspicious activities are flagged, dealt with appropriately on an internal basis, and reported appropriately to the relevant regulatory agencies. Third, the exchanges need to ensure that the KYC procedures are not merely checking a box, not merely making sure that certain steps are followed or certain inputs are put in online, but that they're serious, ongoing, and deliberate. And this means not just taking into account what people say, but actually doing some independent investigation. And the amount of independent investigation obviously depends upon what the facts are, what the issues are, the amount of money at stake, and whether there's any fact in the background of this customer that indicates that a heightened supervision might be appropriate. And then fourth, and this is the thing I want to stress the most, is entities need to ensure that there are appropriate and sufficient personnel for this customer due diligence process. And this needs to be scalable. And one of the things I think we've seen in the digital asset space is that due diligence, customer onboarding, regulatory compliance, all of this is seen as a cost center. All of this is seen as something that gets put on the back burner as you grow the company. And we saw this with the Coinbase case. They had a significant backlog of customer transactions that they intended to check at some point, but they simply didn't have the personnel to do it. You need to hire that personnel. You need to hire the outside compliance experts that you need to make sure that you're adhering to all of the regulations that are appropriate in your circumstance. You can simply say, as Coinbase apparently did for a few years, well, we'll get to that. We're building that out. we're going to eventually come around to checking out all of these past customer transactions. That's not sufficient. Not only can that get you a multi-million-dollar fine, but in the most significant circumstances, that could get you shut down. And I think the recent onslaught of US regulatory cases show that we're about to enter an even more heightened era of regulatory scrutiny in the US. And as I said in my opening comments, any company that has any connection to the US is going to be subject to US regulatory requirements. And as we see in the Binance case, even if you're not registered in the US, but you have US customers or a US nexus, you are going to be potentially subject to the long international reach of US law and US regulators. We're in a very chaotic and somewhat transitional period now, I think, when it comes to the digital asset space. Not every company is going to survive this transitional period, but I think that ultimately it'll be the companies and the exchanges that take these compliance functions seriously. And that means not just having a stated adherence to this, but having the staff and the dedicated focus to this function. Those are the ones that are going to survive and prosper in what I think is going to be a much more heightened era of regulatory supervision.
Right, thank you very much for that, Howard. Bushra, turning to you, what are your thoughts on implementation? How do you see the implementation process for exchanges and any sort of potential challenges that they may face? Sorry, Bushra, you're on mute.
Beg your pardon there. As I was saying, I think the implementation process is probably quite straightforward as long as one can navigate the regulatory regime. And when one looks at the regulatory regime and the implementation process, one can't divorce the UAE's evolution more broadly. I mentioned the central bank of the UAE at the beginning when I was talking about how the jurisdiction works in this market. It's important to note in that context that Central Bank UAE started regulating cryptocurrencies as early as 2017. And in that context, there was a law passed in 2017 which stated that all transactions involving digital assets were to be made through authorized exchanges and had to comply with anti-money laundering regulations set by the central bank. And so clearly, for any exchanges wanting to do business here, there was a very keen regulatory focus, even as early as 2017. And so in terms of implementation, I think the regulatory regime is straightforward. It's very user-friendly. There was a report, a committee set up in 2018 in Abu Dhabi, which was set up to study cryptocurrencies and their implications in the broader economy. And the committee concluded that cryptocurrency doesn't threaten UAE's financial stability or economic system. And instead, it was noted that cryptocurrency could be used as an opportunity for economic diversification and growth if adequately regulated by the law. And so since then, the law has been put into place to regulate cryptocurrency, both at a federal level and at an individual emirate level. And I think what that leads to is diversification and growth. And therefore, where that concerns implementation, the challenges, I would say, are probably going to be limited. And I would also go as far as saying that this is the UAE is a very user-friendly regime because it had at the forefront of its mind industry growth. And so given the long lead time, given in 2017, the central bank was already looking at sort of regulatory processes, I don't necessarily foresee any major challenges for exchanges as long as they can demonstrate compliance with the necessary criteria for obtaining a license. And I quite liked what Howard said sort of at the start of when you first asked him the question, very first question, these are very old criteria, AML, KYC, they're very old criteria in the context of financial services. So it's just a question of adopting those processes and fitting them around cryptocurrency. And just because cryptocurrency is seen as new technology, is seen as something new, doesn't necessarily mean that there needs to be a lapse in terms of complying with the regulatory criteria. And so I think just to sort of round off, the UAE is a favourable environment for digital asset industry growth, and therefore it has a relatively relaxed regulatory approach. That's not to say that there is no regulatory regime and there is no consumer protection, because there is. But when I talk about crypto-friendly regime, the legislation is crypto-friendly, the infrastructure is crypto-friendly, and of course there is zero tax as well, and therefore that draws in quite a lot of business. And just to sort of add to that, in April 2022, two crypto exchanges announced their decision to establish in Dubai. Bybit, I think we've already heard about that, relocated its headquarters from Singapore to Dubai, and Crypto.com created a regional hub in Dubai. And Eric Anziani, I've got a quote from him here, he's the Crypto.com Chief Operation Officer, stated, "We are opening regional head office for Middle East and Africa here in Dubai. It is going to be a great addition to run our operations from here, because the UAE is diversifying its industries and trying to be bold and create opportunities. We are not here only to gain more market share, but to create a broader ecosystem where there are more opportunities for all." And therefore, implementation, in my view, isn't going to be difficult. There won't be challenges. If there are going to be challenges, then of course that it's probably financial crime may grow. I mean, financial crime has seen an exponential growth, and of course the regimes in place, the regulatory regimes in place, are going to protect and prevent scams. And which is why I think anonymous enhanced cryptocurrencies have been banned in Dubai. But if there's going to be any real challenge, then perhaps there are lessons to be learned in terms of what's happened with Coinbase, in terms of sort of KYC procedures, lax procedures, and just making sure that all of those are very tight, as they would be in any financial services entity and industry.
Thank you very much for that. Well, look, looking at it from the lens of the UK perspective, like Bush said, I think it starts with financial crime. I mentioned earlier how it's more difficult for the crypto sector to prevent money laundering, but preventing money laundering on its own isn't quite enough. And I believe firms need to start adopting a sort of best practices approach. And I think this will probably answer one of the questions in the Q&A chat by Darren Jackson. But anyway, moving on, exchanges and blockchain organizations will need to sort of think about applying a risk-based approach. And it starts with the data that you currently have. You need to start prioritizing operational screening, as we've heard from Howard earlier. It seems the UK regulator will be aimed at entities for market entry. And what that means is that your AML and KYC have to be easily scalable. And I mentioned earlier about the draft FPO, and this draft FPO makes clear. Now, this is important. When I read the draft legislation, I found this part somewhat uncomfortable. But when you get a moment, try and have a read of it. But I'm referring to section 13 of this draft FPO. And what it says is the impact on small businesses is expected to be in line with the impact of larger businesses. Now think about that for a second. There'll be no distinction between small outfits and larger businesses. And I would argue that there is a slight imbalance there. The small to medium-sized businesses will be challenged the most, I believe, by these new regulations. If you're a Binance, you have teams, you have compliance officers in place. SMEs, however, are likely to sort of struggle. I already mentioned from a regulatory perspective, we can see that there will be emphasis to look closely at market manipulation. The big challenge is that there will be much emphasis on compliance officers at the firms. And I'm not quite sure if shifting the burden entirely on them is actually appropriate. Crypto assets are globally traded assets, and they can be manipulated at a distance. So for compliance officers to be able to monitor and put policies in place for sanctions compliance, it's a very difficult task. And it goes without saying that those trading venues and exchanges will need the external support. From the implementation perspective, it's good to see that others, what others are actually doing. And I'm glad that you mentioned some of those points, Bushra. If you look at even the MiCA framework in the EU, when you actually look at the regulation and the guidance, it's very similar to the duties of an investment firm and what investment firms have duties have towards their clients. And if you're a trading venue, you can already see how internally you have to deal with governance, financial forecasts, insurance. All of this needs to be understood now. There are a number of aspects for trading venues and exchanges that really need to take certain things into consideration. You need to have HR, you need to have a suitable IT infrastructure, you need to now start thinking about internal audits. What cybersecurity measures do you actually have in place? There'll need to be more sort of transparency on fees. You have to start thinking about the obligations you have when dealing with risk appetite, outsourcing service policies. What obligations do you now have as a custodian service if you're handling crypto? There'll need to be transparency requirements for trading. There's a whole raft of issues which we'll need dealing with. And for smaller to medium exchanges, that can actually be off-putting. And not only that, it might actually be too expensive to handle too. And these are factors I believe that regulators will also need to think about. Now, I appreciate I just gave a sort of long list there, but with the limited time, I thought it might be useful to give you some headline points to take away from this topic. So let's move on. I'm just looking at the time. So we might have a limited time, but let's try and answer the next question because it's quite an important one. We've seen it everywhere. How do you balance regulation without stifling innovation? And I want to ask both of you this question. So Bushra, perhaps I can start with you.
I'm unmuted. Yes, of course. I think the lawmakers in the UAE have always had the objective in mind to impose effective regulations that protect investors but without stifling innovation. And I think one can see that from just observing the evolution of crypto regulation in the UAE. Going back to the report that I mentioned in 2018, because there is this very strong belief that virtual assets can help diversify the economy, the UAE has pushed forward in trying to establish itself as a leading provider of cryptocurrency related services, investments, and so forth, activity relating to cryptocurrency. And the UAE doesn't seem to be too perturbed by what has happened at the back end of last year. For instance, when Bitcoin lost half its value, we had the overnight collapse of Terra Luna, took down 3 hours Capital, Celsius, Voyager, the collapse of XDX, and then what's going on with Coinbase, and obviously critics have dubbed crypto markets the Wild West, but that hasn't meant a more aggressive regulatory regime in the UAE, especially because the VARA regulations were published in February this year. And so in terms of my own personal view, for crypto regulations not to stifle innovation, I think it needs to have a few key elements, and that is one, that they need to be clear. It's difficult, and we can see the effect of not having any workable definitions and the impact of that, and therefore any regulation or any regulatory perimeter has to be clear, it has to be well defined. The users of those regulations ought to know what they're buying into. The second thing I think is it has to be strong and flexible. Clearly innovation, whilst it requires independence, but that independence has to be within the legal safeguards provided for by the regulators. And so therefore they need to be strong, but they also need to allow finance technology to grow. And what I've seen in the DIFC is that it has established complementary initiatives to allow development of innovation. For instance, it set up the FinTech Hive, it set up an innovation hub, and that's nearly home to about 500 companies in the fintech space that will develop sort of finance technology. There's going to be a summit this year, for instance, in May in Dubai, that will host about 5,000 global fintech and tech experts. They'll come together, they'll discuss innovation, challenges to the sector, they'll spotlight anything impacting the future of finance, they'll talk about decentralized finance, regulation, policy making. And so, yes, regulation is important because it has to protect the consumers. One has to have confidence in the market in order to enter the market and for there to be business growth. But equally, I think what Dubai is doing in terms of not stifling innovation is to have those complementary initiatives that support the regulatory framework, for instance, as I've mentioned, FinTech Hub, and also lawmakers. I think lawmakers and the enforcers need to act faster. We've seen how fast the crypto market moves, and therefore with that in mind, I think those enforcers ought to move as fast as the crypto market. And with that in mind, again, the DIFC Court has set up its own digital economy court designed to keep pace with technologies. And so I think in answer to your question, regulation can be balanced without stifling innovation. And you see that in the approach that Dubai has taken.
And I think in the US, we're seeing a slightly different approach to it. And there's a lot of criticism in the US that regulators are effectively putting new wine in old bottles, and that regulation is anathema to the ethos of the crypto space, which is libertarian, decentralized, unregulated. But I think if you look at the timeline, and I'm going to point people to the recent statements by the US Blockchain Caucus. And for those who don't know, in Congress, different interest groups are organized into caucuses. Some are more partisan than others. And there's what's known as the Blockchain Caucus, which is a bipartisan group of legislators who have gotten together to promote the growth of the digital asset industry in the US and to make sure that there's as light a regulatory touch on that growth as possible. And in April of this past year, Representative Emmer, who is one of the co-chairs of that caucus, wrote a very nasty public letter to the SEC when it came out that the SEC had investigated and was investigating FTX. And this letter argued that the SEC was in danger of stifling an important area of innovation, entrepreneurialism, and growth, and it better back off, or else there was going to be trouble. And there were a series of Twitter posts by Tom Emmer, the chair of the caucus, basically threatening the SEC for trying to interfere with the golden goose of digital assets. After FTX collapsed, Representative Emmer had another Twitter post which said, "I can't believe the SEC was totally out to lunch. Where are the regulators? What were they doing? How did they let this happen without getting more actively involved?" So, the US is subject to probably more than many other countries, a regulatory pendulum where we go back and forth, often on a dime, with the way we look at things. And I think that if you had asked that question a few weeks or months ago, the answer would be, we need to have less regulation in the US so that we could promote growth. But I think after the various failures that we've seen, and I'm including in that the failures of Silvergate Bank and Silicon Valley Bank, that there is much more of an attitude in the US of promoting regulation, which I think highlights the importance of regulatory compliance and adherence, because right now everybody is going to be under incredibly heightened scrutiny. And if a company is not ready for that, if they haven't scaled up for that, if they don't have the personnel to deal with their internal compliance obligations, they're going to find themselves named in an investigatory report or a consent order or an enforcement action like Binance recently was.
Thanks for that, Howard. I think for my part, certainly when looking at it from the UK perspective, I think we need to look at the rule book of the FCA. Now, we know Europe has legislation. The FCA has the handbook, and it is quite sort of rigid. And for me, the FCA will need to go back to when they used to have the code of conduct. There needs to be a code of conduct which provides the flexibility which is required. And this will help strike the balance that both of you have referred to. Interpretation of text and regulation is important, and it's an important need to understand the crypto ecosystem as a whole. I'll probably leave it there because there's a couple of more questions I want to ask you guys, if that's okay. Howard, really quickly, what are the lessons to be learned from the penalties that you've mentioned throughout this webinar? And due to the time frame, perhaps you can just focus on those sort of headline points.
Yeah, I mean, I think that the headline point is that you can't look at compliance as a cost, because deferring compliance, deferring hiring, deferring having a robust internal compliance and regulatory adherence structure is ultimately going to cost you far more down the road than dealing with it is now. And those costs can be either in the form of fines or, at the worst case scenario, a shutdown of the company.
Perfect. Okay. I can see we've got a few questions here. So before we get to those questions, Bushra, just really quickly, a couple of minutes. Is there anything you'd like to add to this when sort of considering VARA and everything else that we've discussed?
You've had my comments. I think just sort of reiterating what Howard was saying in the context of penalties and compliance. I think AML, KYC, all of those things are fundamental for investor protection. Obviously, kind of the level of fines isn't as significant as the ones that we have seen in the US. Nonetheless, there are sanctions in place. But having said that, you know, VARA, it's seen as being quite a regulatory, a friendly regulator, and it sort of fits in with the essence of Dubai and what it's trying to promote in terms of its crypto industry.
Okay, great. Well, thank you very much. All right, so I'm going to try and go through some of these questions that have been asked. Let's see here. Okay, so one of the questions is, what is the current system for the jurisdiction regulators, UK, USA, UAE, sharing common information, intel specific to crypto digital functions? So it's more about cooperation. Howard, perhaps you want to...
Yeah. So, you know, when I was at the SEC, we commonly did joint investigations with other regulatory agencies around the world, and there are international treaties which govern that. There are sometimes a memorandum of understanding that are entered into on a specific case or investigation, and that can include things such as sharing documents, sharing databases, to jointly interviewing witnesses together, and to, you know, work on prosecution briefs together. So depending upon the case and the situation, the cooperation can, in fact, be quite extensive.
Okay, brilliant. Another question here. At times, exchanges can have backlogs of various important tasks that relate to compliance. How can this be effectively dealt with without being penalized? Okay, that's a good question, and I'll deal with that if that's okay. Targeted remediation plans is actually the way to deal with that. If you look at the cases that were referenced, Coinbase and the rest of them, as we heard earlier, the lack of knowledge they had about their customers exposed them to money laundering risks. The lessons to be learned is to have the adequate KYC, because that puts the solid foundations in which you require to actually sort of operate. AML and KYC have to be easily scalable, and it's important. It's an important part of business risk assessments, the ability for it to scale with your books of business. And you have to sort of remediate any weaknesses that you have. And the good news is today there are actually tech tools and AI and software that's available to support you with this, to deal with both the AML side and the remediation side. And just remember, you know, growth is good, but be mindful to ensure that compliance grows with it. And I'm sure all three of us today have touched on that throughout the webinar. And the reason for that is, as we know, the penalties can be quite high, right? So that's that. Okay, then we've got a question here. Following the news that the Central Bank of the UAE has launched the digital dirham, please can the panel comment on whether they see this impacting the existing UAE international regulatory landscape, and what, if any, changes will be needed to support this initiative? And number two, do you think this move will further leverage the MLETR adoption across the UAE? Could we see documentary credits backed by DeFi and settled in CBDC? And how would that impact the regulatory landscape? Mouthful, but Bushra, I'll hand that to you if that's all right.
Yeah, no, absolutely. Yes, so there's been a huge furore at the moment of the central bank sort of issuing its digital dirham. I mean, there's clearly going to be a number of aspects that are going to be impacted by the issuance of the digital dirham. For instance, retail consumers will be impacted. Obviously, it's got to be sort of secure, convenient, and affordable. And whilst it might give retail customers those benefits, notwithstanding that, it also has to be balanced with the fact that they are protected when they're using the digital dirhams. Corporates, it will impact corporates because they could see money benefits. Obviously, that will be sort of complemented with smart contracts and value-added tax, and whether or not the VAT will be applicable to transactions dealing with digital dirhams. I think in terms of kind of local banks, they might be more affected by it because they will have to obviously change the framework within which they operate. It's going to create lots of opportunities for fintech, and obviously it's going to mark a complete shift in the operations of the central bank. So coming back to whether or not that will impact the existing UAE international regulatory framework, I can't see how it won't, is a simple answer, because this is a financial service, it's a digital asset, it's a digital service, and therefore inherently there's going to have to be some sort of a kind of regulatory framework governing this in order to protect those users and consumers that are going to be sort of using the digital dirham. Then turning to the, I think the next question, will the move further leverage the MLETR adoption across the UAE? I haven't really seen kind of a big sort of adoption of the UNCITRAL MLETR model. And so whether or not it will leverage that, I'm not sure. I mean, the UAE is keen to adopt these sort of models in terms of when they kind of transact, when they do business. And so possibly, could we see documentary credits backed by DeFi and settled in CBDC, and how would that impact the regulatory landscape? We might do. I mean, in the DIFC, the sort of crypto regime has gone through various stages, and the third phase that's going to be rolled out is they are going to issue consultation papers for DeFi and how that's going to impact the regulatory framework. So in the DIFC, they're already looking at that. So possibility that it will. In the UAE, haven't really heard anything about sort of DeFi and what's happening there, but certainly in the DIFC, it may well happen. So I hope that's answered the question.
Great, thank you. There's a question for all three of us, and that's: how does VARA, SEC, and FCA define crypto assets? Howard, if I start with you, and then Bushra, and then I'll come in as well.
Yeah, I mean, you just have to read the news to see another crypto asset has been defined as a security by the SEC, which means if it's a security, it has to be registered, regulated by the SEC, and if it's offered to the public without being registered, all of those offerings can be rescinded. So, starting in 2017 with this involving ICOs, initial coin offerings, and extending until last week's Wells notice to Coinbase, it's pretty apparent, and Chairman Gensler of the SEC has said that perhaps other than with the exception of Bitcoin and Ethereum, every other digital asset is a security. And this might even be extended to things such as NFTs. There was recently a decision by Judge Marrero of the Southern District of New York involving NFTs, in which he held that maybe NFTs are securities as well. So the quick answer to that is, it now looks like everything, at least according to the SEC, is a security.
Okay. Bushra?
Yeah, I've got the law open in front of me, and that's in Dubai, the law number 4 of 2022, regulating virtual assets in the Emirate of Dubai. Virtual asset is defined, and that is a digital representation of value that may be digitally traded, transferred, or used as an exchange or payment tool, or for investment purposes. This includes virtual tokens and any digital representation of any other value as determined by VARA. Now, I know that that definition isn't uniform throughout the UAE. For instance, the DFSA has a different definition, and I know that the ADGM has a different definition as well. And I was trying to very quickly find it, but if you do go on the DFSA website, one can find it. It hasn't come up yet, but the definitions aren't uniform. And I think I looked at this when I was looking at the sort of Tabarak case. I don't think there is any uniform definition of what a cryptocurrency is, what a digital asset is, what a virtual asset is. Not that I've been aware of anyway, not that I've found.
Okay, great. From the FCA's perspective, is actually very similar to what you've just outlined. And what crypto is thought of as a digital representation of value or rights that are secured by encryption, and it's usually some sort of DLT, so distributed ledger technology. In the UK, there's obviously a framework to deal with these types of matters, and it has been for quite some time. And if you look at case law, certain coins, so Bitcoin, for example, have been defined as property. So in the very first case, which is AA versus Persons Unknown, a case that we were actually involved in that case, the High Court came to the conclusion that crypto assets such as Bitcoin do actually meet the definition of property. All right, maybe one more question. I'm really sorry, we've got loads of questions here, but due to time frame, we won't be able to go through all of them. All right, there's one from Adam Crissel. It says, in a couple of words, given the time remaining, what role has custody played in enforcement actions in your jurisdiction? This is a big issue in Canada. Okay, I'll start really quickly on that, because we can see what there isn't any live examples from the UK just yet, because of what we were mentioning earlier in terms of regulation and the fact that it's coming into play. On the 30th of April, the consultation period will conclude, and I think there will be regulations in place very soon from the UK perspective. But when you look at the guidance and when you look at the draft FPO that I mentioned earlier, custody is something that's extremely important, and it's something that plays a vital role. And no doubt we've seen that in some of the cases that Howard referenced earlier as well. I don't know if anybody wants to add to that or not.
Can I?
And I'll just note that, oh, go ahead, Bushra.
No, after you.
I was just going to say that the SEC has just proposed new rules about custody of digital assets, well, custody of all assets, including digital assets. And I think a fair interpretation of those custody rules will almost certainly eliminate digital assets as an asset class for investment advisors and broker dealers. So it's an issue that we are wrestling with. There are proposed rules. Those rules have been controversial, and it's unclear if they will be ultimately adopted in that form.
I was just going to add to that. So in the case that we did, the Tabarak case, one of the issues there was custody of Bitcoin, and whether or not the first defendant who I was representing had taken custody in the sort of traditional custody and escrow services sense. And the judge had found that it hadn't. And so this is now sort of going to be an issue in terms of aligning what those traditional custody and escrow services are with the custody of Bitcoin, particularly where Bitcoin, let's say, is stored in various different digital mediums and by various different digital mediums. But the interesting point there is, because I think Adam's mentioned Canada, it's a big issue in Canada. Two of the experts that we had three experts, and two of the experts that we had were from Canada, and they were actually quite vehement that custody, even if you've taken sort of it in your control, was akin to providing custodian services and escrow services, such that it led to liabilities and led to a cause of action. So it's quite interesting that actually that you mentioned that it's a big issue in Canada.
Okay, well, look, there's so many more questions, but perhaps you guys can email us or send us a message on LinkedIn or whatever it is, and we will try our best to answer those questions, because a lot of them are really engaging, actually. However, given that we've now approached the end and it's nearly 2:45 p.m. in the UK, I think now is a suitable time to bring this webinar to a close. I want to thank the panelists who have taken their time to share their insights and experiences. And I'm very grateful to the audience who have attended and submitted questions and have listened patiently to us for nearly an hour and 15 minutes. Like I said, please do feel free to email any one of us directly if you do have any queries or comments. But for now, thank you very much, everyone, and take care.